Case, please.
Courtney Anderson versus State of Tennessee.
Good morning, Your Honors. May it please the Court, Nick Spangler for the State of Tennessee. If I could, I'd like to request 3 minutes of rebuttal, please. Thanks so much. Your Honors, this is a state appeal from an order from Shelby County Criminal Court reopening post-conviction proceedings and granting post-conviction relief in the form of a sentence reduction that saw Mr. Anderson released after service of 25 years of a 160-plus year sentence. So the order reducing Mr. Anderson's sentence and releasing him should be reversed because the trial court lacked jurisdiction to grant that relief. And the court lacked jurisdiction to grant that relief for 3 reasons, any one of which is an adequate basis to reverse the trial court's ruling.
General, let me ask you this
Sure.
question. Are you not bound by an agreement between the DA and the defense that took place at the trial level?
Not in this case, Your Honor, not in a post-conviction case.
Okay. Can you explain to me why?
Sure. Because there are statutory prerequisites to granting relief in a post-conviction case, and those prerequisites are jurisdictional. It's well established that at least the statute of limitations is a jurisdictional prerequisite. That's both in the post-conviction statute and in this court's precedent. And more recent cases, both in the Abdurrahman case and in the Nichols case, established that there are other jurisdictional prerequisites to granting post-conviction relief. So that's the reason why. We're dealing with a situation where we have a final judgment here. This is not a case that's, getting ready to go to trial where the DA and the defendant can come to an agreement and they may be bound to that agreement. We're dealing with a final judgment, and so the only way to undo that final judgment is if you can pass through the gateways of the Post-Conviction Procedure Act or some other form of collateral review. And if there's not a basis to do that in the record, then the trial court lacked jurisdiction to grant relief. So again, the first jurisdictional prerequisite is the statute of limitations, and that statute of limitations applies not only to original post-conviction petitions, but also to motions to reopen. And there's no real dispute here that this motion to reopen was filed many, many years after the statute of limitations expired. I think it's approximately 16 years after the finality of the judgment that this motion to reopen was filed. So the only real dispute here is...
Can I follow up on
Sure.
Judge Dyer's question? What was the constitutional violation that the state agreed existed?
So I think the state basically agreed to the same thing that was alleged in the motion to reopen and to what the trial court found, which was the allegation was that it was a claim under Section 117A3, which stands for the idea, and that's a codification of the constitutional ruling in Burford, that the sentence was based on a prior conviction that was subsequently held to be invalidated. So that's the claim, and I'll talk about that more in a minute, but the problem with that claim is...
Are there a lot of issues with it? The state agreed that the prior sentences were invalidated?
Not expressly, Your Honor.
Okay. Was there an agreement at all then?
There was an agreement to the grant of post-conviction relief, but not to the specifics that would permit the grant of post-conviction relief, if that's a way of putting it.
Did the trial court make a specific finding that the previous sentences were invalid?
There was, well, first of all, there was no finding that the prior convictions were invalid, which is what's required.
Sure.
But as to the other part of your question, the sentences, what the court found is that those were eligible for reclassification under the 2017 theft amendment, which...
How did the trial court distinguish Keys?
It didn't at all, Your Honor.
Did it address it at all?
It didn't address it at all, and that may be a product of the fact that the state didn't raise it below.
So basically what the trial court did here, and as I read your brief and the defendants as well, it's not 100% clear what the actual claim is, but basically what the trial court did here is took the new graduation of theft statute, and because some of his enhancing sentences for this case would if tried now, be misdemeanors.
If tried now,
Right?
correct.
If tried now, it would be misdemeanors
Sure.
as opposed to felonies.
Sure.
That somehow, basically, maybe not expressly, but basically the court found that invalidated those. So therefore, that's how the court got to the post-conviction statute there, and that because those were invalidated as enhancers, he's entitled to relief?
I think that's the theory, Your Honor, and it's tough because we say that it traveled under 117A3 because that's what it most closely resembled, but it didn't meet the requirements of A3. But that's my understanding.
But to follow up on
Sure.
Judge Greenhold's question, none of this is expressly in the trial court's order.
The post-conviction reopening statute, I don't even believe is cited in the post-conviction court's or in the trial court's order. So the only thing that the post-conviction cites, or the only rationale that the post-conviction court says as to why it's granting relief is it says the original sentence is excessive, the underlying convictions for the sentence are of a nonviolent nature, and then it cites to this 2017 Theft Amendment reclassification argument.
But as we were discussing, I'm sorry, Judge, go ahead.
No.
But as we were discussing, though, the trial court must make a finding that the underlying convictions are invalid.
Correct.
At best, here with the, I guess, the regrading of the offenses following the Public Safety Act of 2016, at best, you would affect the sentence, but even Keith puts the light of that.
Exactly.
Was there any finding at all that the underlying convictions themselves?
No finding whatsoever, and no pleading to that effect either. There was no allegation or suggestion by either of the parties that the prior convictions had been invalidated, and there was certainly no finding by the trial court that the prior convictions had been
So
invalidated.
did the office of the district attorney object to the petition at all on that basis?
I don't believe there was any objection to the petition at all. I believe it was a complete agreement up and down that this petitioner was entitled to post-conviction relief. There just was not an adequate statutory basis for the court to have granted that
Are
relief.
parties able to agree to post-conviction relief?
They are not, Your Honor. There's very specific case law. I think Abdurrahman is the most recently published decision on this. And I think maybe also the court's recent decision in Byron Black, that a post-conviction court lacks jurisdiction to modify a final judgment without a constitutional violation sufficient to grant post-conviction relief, and that the parties just can't come together and agree that there's a violation in the absence of one in order to effect post-conviction relief.
In fact, it even goes further than that, right? I mean, doesn't our case law recognize that the trial court must make findings
Correct.
and may not simply rely upon the agreement of the parties?
Correct, Your Honor.
So what were the findings made here then with respect to the reopening of the post-conviction petition?
Again, the only thing I can point to with regard to findings are the findings that the sentence is excessive, that Anderson's underlying convictions were nonviolent in nature, and that the prior enhancing convictions were eligible for reclassification. That's it. That was the only basis that the trial court cited, or the only rationale that the trial court provided in support of post-conviction
So
relief.
basically what you just repeated to us, none of that is a basis for opening, or even getting you in the door jurisdictionally,
Correct.
but even more so granting relief after you're in the door.
Correct. It's not a basis for statutory tolling of the statute of limitations. It's not a statutory basis for reopening post-conviction proceedings, and it's not a constitutional basis for granting post-conviction relief.
I'm confused about one thing. What
Sure.
happened before the trial court stated that, or confirmed that she had already signed but not yet entered an order finding the petitioner's sentence excessive? Was there any kind of hearing?
All that there was, Your Honor, was sort of an announcement in court that this order was going to be signed, and then the assistant DA stood up and basically read the details of the amended judgments that were going to be entered pursuant to the grant of post-conviction relief. So it wasn't even as if the written order that was filed was read in open court. All we have is the written order in terms of the rationale for why the trial court granted post-conviction relief. So there was no real discussion other than the parties have agreed. There is a basis for post-conviction relief, and read the amended judgments. That was all that happened in open court.
So the judgment was prepared before the parties announced they agreed?
That's my understanding. The record's very limited on that, but it is clear from the record that the court, when it came out, it sort of announced that it already had this written order, I believe, signed written order, and then they proceeded to have the colloquy about the amended judgments and what those would reflect. And then I believe the court entered the post-conviction or the final post-conviction order.
So let me follow that line of question.
Sure.
as I read the briefs, and admittedly, the hearing is like this long, and I did review it. And you allude to it maybe in your brief, but you don't come right out and say it. Two things that seem to trouble me. One, it appears that the trial court and the DA engaged in ex parte communication prior to anything happening. Where the trial court makes a statement, this came to my desk, and I called the ADA in here and said, we need to fix this. One, do you agree that would be ex parte communication? And two, just why is it not something that the state brought forth in its brief?
I will say that I'm uncomfortable affirmatively saying that it is ex parte communication because we have such a limited record about exactly how that went down. It may have happened in open court when the DA brought it to the court's attention. I just don't know because the record isn't that specific. So.
Well, I mean, how I read the transcript was this came on my desk. I called the ADA in here, I think was the term.
Sure.
So to your point, I don't know if in here is the courtroom, in here is her desk truly in the office.
Sure.
Okay, that's the first.
And one follow-up to the first question, too. This is maybe a little bit of speculation, but I know there were some motions filed before this motion to reopen. I think maybe even some pro se motions. And I think that's how this particular trial judge came about to handle this case.
That was going to be my follow-up to
Yeah.
that. So there is a counsel of record on the motion that's in the record.
On the motion to reopen, yes, Your
Yes.
Honor.
So do you know, and maybe your review of the record's the same as mine, what came across the trial judge's desk, is that the motion that's filed by counsel, or is that the pro se?
That's the motion filed by counsel.
Okay, so back to the ex parte communication comment. Defendants represented by counsel, way I read the record, maybe you read it differently, defense counsel's not involved in that meeting.
I can't say based on the
Okay,
record that I
that's fine.
have. Yeah.
Second thing is the way I read the record, and this is what Judge Holloway was just talking about. I mean, it seems pretty clear that whether the DA agreed to anything or not, that this was resolved before there was ever actually a hearing.
I think that's fair to say, given that everyone showed up for this quote-unquote hearing with an order already signed. I think there was an understanding between the parties about what.
Well, I question whether there's an understanding on the state's position, on the state's end, because as I read the transcript, the ADA stands up at the beginning of the hearing, if you want to call it a hearing, and says, it's my understanding, Your Honor, you have amended judgments and a signed order in this case. I mean, I would, if I were part of the deal, so to speak, and part of the negotiation, I wouldn't stand up and say, it's my understanding. I'd stand up and say, Your Honor, we're here on this and I have these with me.
Sure.
I mean, did you read the transcript the same way I do? You don't want to say.
Yeah, all I know is what I have, which is, they show up to this hearing. There's an order already in the trial judge's hand that's not been filed yet, but has been signed. And it's clear that the parties have agreed to post-conviction relief. It's clear that the court is inclined to, and is going to grant post-conviction relief. And then there's a recitation of what is on the amended judgment.
Prior to hearing any proof or having any sort of hearing.
Correct, Your Honor. And I will say, I mean, not in defense, but for a motion to reopen, oftentimes it is just a legal question that may not necessitate the putting on of proof. I think for
But there's at least argument as to why it
Sure.
should or should not be reopened,
Sure.
not we're opening court and here I'm entering an order.
Sure.
Okay.
Well, I mean, but once again, we get back to the issue that the convictions themselves have to be invalid.
Exactly, Your Honor.
And so to the point that, yes, it may be a legal question, there still has to be some sort of proof. In order to establish the relief he was granted here, there has to be proof put on that those were invalidated.
I would agree with that, Your Honor. I think it would take the form of a new judgment.
And there was that didn't take place here.
Exactly. And there was no allegation that those those prior convictions had been invalidated. It was kind of a close but no cigar situation. Everyone thought they were traveling under 117A3 because of the reclassification issue, but that just doesn't meet the plain language of the statute, and so nobody really considered the actual requirement of 117A3, which is the invalidation of the prior conviction. So there was no allegation of an invalidation, there was no allegation of an invalidation, and there was no finding of an invalidation of a prior aggravating conviction. I think we've covered most of what I would cover here. Basically, the statute of limitations is jurisdictional. It barred relief here. I will say a little interesting twist to that is the petitioner didn't travel under one of the statutory basis for tolling. The petitioner actually pursued a due process theory of tolling, which, as the court knows, is a two-prong analysis, extraordinary circumstance preventing timely filing, and then due diligence. And again, in support of the extraordinary circumstance prong, the petitioner asserted the same thing, this 2017 theft reclassification argument. And again, that's just simply wrong for a couple reasons. A, the prior conviction wasn't invalidated, and second of all, Kesey says that when you have a sentence that's final before the amendment to the statute, you don't get the benefit of that lesser punishment statute. So that's the statute of limitations.
But even then, the diligence issue, my guess is that it would start to run on January 1, 2017.
That's exactly correct, Your Honor. That was, I think, the point we made in our brief, is even if that were an extraordinary circumstance, we have between 2017 and the motion to reopen filing date, which was 2022, so we've got 5 years there. So certainly that doesn't meet the prong for due diligence. And then we submit the trial court lacked jurisdiction to reduce Henderson's sentence because no statutory basis for reopening post-conviction proceedings was pleaded or found. I think we've covered that. And then also no constitutional violation was pleaded or found. I'm happy to answer any questions the court may have about that. I might bleed over a little bit into my rebuttal time, if I may, just to address the issue with the appellate record, because we have sort of hinted at that this appellate record is admittedly sparse, but our position is that it's more than adequate to establish the jurisdictional defects that the state has raised here.
Can we not take judicial notice of all of our records?
Sure, and we've requested that. As an alternative to supplementing the record, we've asked that you take judicial notice of all the prior appeals and post-conviction proceedings, or post-conviction appeals in this case, which should be the complete record of proceedings in both the original case where he pleaded guilty and the later cases, there was, I think, 17 different counts where he was tried and got the 140-year sentence. So either or would be fine. We were in a little bit difficult position because our main position is that the record is adequate, but to sort of cover our bases, we've requested that the record be supplemented if the court is inclined to find that the record is inadequate for any reason. But our position is that the record is adequate to show these constitutional defects. The best way I can put it is we need nothing else in this record to establish that.
That was my question. Do we even need to look at the prior records?
We don't. We don't, Your Honor.
Resolve this issue one way or the other?
We don't. And I think one thing I'd point to is, as far as the prior thefts go, there was an exhibit attached to the motion to reopen that listed some of these priors, and it listed the theft, and I think the date and the classification as an E-felony. And that's what the trial court cited to in its order granting post-conviction relief that said,
Yeah, so even if we were going to find that this did, the 2016 Act did invalidate these, we don't need our prior records to determine.
Correct, Your Honor. And all 321 amended judgments are in this record, so you can see what the court's done with these sentences. And so unless there are further questions, we respectfully ask that you reverse the decision of the trial court and vacate the amended judgments entered and reinstate the earlier judgments and uphold this 160-plus year sentence. Thank you, Your Honors.
Thank you, Ms. Mr. Tubman?
Yes. Good morning. May it please the court, Attorney Terrell Tootin on behalf of Mr. Courtney Anderson. First, I want to start off by saying, again, it kind of got touched on, but I want to further clarify. When you have concerns about what happened and all you have is one day and the representation that that's what the record is, we object to that. That is not what the record is. We didn't walk in one day, meaning Courtney Anderson or behalf of the appellee, and have one moment in time on that one transcript. What needs to be clarified is that, as argued in our brief, the entire record wasn't provided. So there
What other hearings were there? What's left out?
There was multiple settings. That was not the first setting. This case was discussed before the court multiple times, where the parties had went in before the court. I wasn't on the case the entire time either, but this case did not happen in one day, in one moment, and that is the appellant's job to bring forth all the times in which this matter occurred. Going to the other point about whether there is proper tolling and a question about what has been happening and, hey, shouldn't it have run in 2017? Well, I believe part of the court's ruling was that after the court reviewed all the different pleadings, transcripts, and motions, is when that was how she reached the conclusion that there was a sufficient basis to do the tolling. So just taking judicial notice of the prior appeals would not complete the record, because that doesn't provide all the documentation or filings that would have been happening in between the appeals or the different steps that.
But that's your burden. Your burden is to show, if you're going to argue that you're diligently pursuing your rights.
Yes.
Then you have the burden to make sure that those things are included, to show that you were diligently pursuing. Because you have to meet the jurisdictional question before we ever get to the merits of your claim.
And so, and my response to that is, when we've submitted, as far as Mr. Courtney Anderson, what we believe was sufficient, and then the court reviewed the entire record in addition to what we submitted, and that she agrees with it, the trial court, and then the state doesn't oppose it, as our position is we no longer have anything else to present. So what I'm saying in another way is, if once we've presented evidence that the state agrees is sufficient and the trial court agrees it's sufficient, it's now unfair for us in this point to say, well, actually it wasn't sufficient, and now that's Mr. Anderson's fault, because if there was anything else that needed to be presented, we would have. The entire record, the different documents was all before the
So
court.
what are we missing? Just tell us what we're
Okay.
missing. If you keep saying there are these different documents and different hearings, what are we missing?
So there's, from my recollection, there is at least 2, if not more, banker's boxes full of these different filings. There's, in addition to that I know of personally, there were the different indictment sheets and orders that were in there that explained every case that would.
That's the old record. That's what you're talking about. You're talking about the old record, his original trial, his post-conviction, and all those things. What else was filed
Yes.
for this specific motion?
I want to be clear.
It's not already in some record somewhere.
So I want to be clear, we're referring to the additional records as the prior records as well as everything up until now, because when you're talking about due diligence and are you pursuing it, you have to look at all the conduct that has occurred. And so to add to that, I'm not saying that banker's boxes only has
What
old
conduct
records.
occurred between the passing of the act, the date of the act in 2017, and the date that the motion we have was filed? What actions occurred that showed he was diligently pursuing during that window?
So my understanding is that my client, Mr. Anderson, also reached out to the state of Tennessee. He was trying to pursue a clemency, I believe, and so there were different documents he was sending about this case. It goes
That
to
doesn't
show
have
that
anything
he's
to do with the
pursuing.
2016 act.
Well, that all happened after this to show basically what he was arguing. And again, I want to be clear, I don't have the document, I'm going off of what I understand as an officer of the court, is that he had referenced the act, referenced these things, and my understanding is he was actually set for a clemency to have the hearing, but it got canceled after he got released on this. So he did that. There was also the Freedom of Information Act documents he was requesting to get these documents from the state after he had issues with his appeals and they weren't successfully. And he was getting, my understanding is that the state didn't produce the documents. He got a letter basically responding to his request that they would respond, but
When
never
was all
ultimately
this
did.
presented to the trial court in this matter?
So that goes back to my point. All of these documents, all the pleadings were all part of his file, which is part of the things that were in the banker's boxes and things of that nature. So my point, and I wasn't on this case the entire time, but my point is when we're talking about the entire record, all of those things are part of the record. So when I'm referring to the banker's boxes and the documents and the things that are happening in between the appellate court, I wasn't filing those things on behalf of Mr. Anderson, but I know those things were happening from speaking with him and talking to him. And so my point is, when he is pursuing it, and if the judge is reviewing all of these things.
Okay.
Go ahead.
So assuming we agree with you, assuming we agree that your client diligently pursued this and therefore the statute is told, legally, how do you get the relief you got?
So I think there's a couple things. One is that there's an issue as to, so when the judge made the comment about excessive sentencing and things of that nature, I want to clear that up. That, I think, was based on a review of the record and the document she had. But there is no true, I think the argument of opposing counsel is that she somehow illegally converted a sentence. We disagree with that. What we're saying is when you have, what happened in this case is he pled open. And when you find out that there's a mistake in the sentencing phase, you put the judge back to the spot as we were.
Legally, what's the mistake?
So I'll jump there first and then circle back. So there was multiple things, like the judge did reference in her ruling, is that she saw where, there was a couple things. One, she saw where, and she cited to the TCA, it's in the footnote, where there was the theft of properties that were reduced to misdemeanors, and that was no longer a valid conviction as a felony.
No,
She-
it doesn't make it an invalid conviction. It doesn't make it an invalid conviction.
How is the conviction invalid?
Well, it was not a valid conviction as a felony, is what, specifically.
How do you distinguish Keese? Keese holds exactly the
Yes.
opposite to the position that the trial court adopted. So how do you distinguish Keese?
Well, I would say that in this case, when you have, so a couple things. I think that's why it goes back to the record and why she said it was excessive. When you have a ruling or a trial court where he's pleading open and the judge is making these positions about giving him this time for nonviolent offenses, and he's specifically saying, because of this being a felony and because of this being a felony, I will thereby give you this sentence. And then that sentence is not the basis. Our position was that is how one way would be invalid. But in addition to that, if you look at the order, the judgment sheets that was entered, there was additional, I believe, 2 other felonies that were nolle prosecute on that day, on December, I believe, 13th, 2022.
How about we just take for argument's sake, that I agree with you, just for argument's sake, that the 140, 150-year sentence was excessive. I don't know that I believe that, but let's just take that as a given. How do you get into court under the Post-Conviction Procedure Act? There may be other remedies that are available, but under the Post-Conviction Procedure Act, I think you would have to show that the prior convictions were invalid. And the only response I think I've heard to that is that the Public Safety Act, which came into effect on January 1, 2017, would have reduced the felony sentences to misdemeanor sentences, not affected the conviction, but the sentence. And that in and of itself may be okay, except the Supreme Court has said no, that after those sentences are final, Public Safety Act doesn't affect them at all. And so I don't have a conviction that's been rendered invalid. Under Keese, I don't have a sentence that's been rendered invalid. And although I may have remedies in other places, how do I get in the door via the Post-Conviction Procedure Act?
Now, so I believe it started off as a motion to correct a legal sentence, then it became a motion to set aside guilty plea, and then we ultimately ended here. But as it relates to the first issue that you raised about whether or not we get through the door, I think the difference, at least what we believe the key difference is here, is when you have a trial court judge enhancing these sentences and saying that part of the basis for the enhancement is specifically. So each sentence is an individual.
But
Specifically what?
Keese says the exact opposite of what you're arguing, though.
I think
So
that-
how do you get around that?
Well, I think when you have a trial court, so I think it's different, and I would submit it's different if you just had one case, because each sentence represents an individual case. And when the judge is using that as a basis to treat this person more excessively than basically taking a nonviolent offender and treating them in a way that you would treat a violent offender and basing it on these things, I think that in that scenario, I think it's different, because what you're doing is you're taking these sentences and you're, in my belief, you're taking a conviction and using the basis of it being a felony to enhance it, and then saying that although this would not typically take you to this level as I would treat a violent offender, but I'm now going to take not just the sentence, but the amount of these felonies and now treat you in this way. And I think there's a
But again,
difference. I understand.
I go back
I
to Judge
understand the
Greenhall's
question. I do think
question
it's
and
a difference.
premise. Assuming we agree with you that this sentence is excessive, an excessive sentence doesn't get you in the door of a motion to reopen. I mean, assuming I agree with everything you're saying about how you're taking a nonviolent offender and treating him like you would an extremely violent individual by giving him 146 years or whatever the number is. Assuming I agree with you and think that that's just not, quote, right, okay. However, how do you get in thinking it's excessive doesn't get you in the door under a motion to reopen.
So I guess our position to that would be, once, it's not just that it's excessive, because again, you could believe objectively or subjectively that it's excessive, and that doesn't start this proceeding to roll. I think what makes it different in this case is when you have the previous trial court concluding that so again, I think the difference in Keys, at least I believe is the difference, I'm hoping you believe it as well, is that it's not just we have a prior case, this prior case is done, and since that was used as part of this determination, it's over. It's nothing else. This is settled.
Isn't that exactly what Keith says?
I think that's what Keith says. I think the difference here is that you have a prior conviction, and then you have the court saying this prior conviction is in fact what I'm now using to enhance this other conviction, because by pleading open, they treated each one as you can imagine, a separate conviction, and saying this conviction is now being used to not only enhance this position, but now to treat you more so like it's someone who is a dangerous offender. And so the prior case is being used twofold by the court to enhance the number and then to treat him in a more significant range.
Prior case hasn't been invalidated.
Well,
Again, assuming I agree with you that the use of 3 thefts to create a 146-year sentence is excessive, okay, but until you invalidate those 3 thefts, which the law is very clear has said that the 2016 Act doesn't invalidate those convictions. So until you invalidate those convictions, how do you get in the door?
and then in addition to that, to answer the question, and in the record will show this, then there was also 2 other forgeries that were, I would say, was considered invalidated and nolle prosecute on that exact same day. So even if you're not relying on, and the state didn't challenge that at all. You don't see that in their brief or saying that there was an issue there at all. So now, even if you were to say, okay, well, the initial door you weren't in when we went through a window, there was another option to get in there because at a bare minimum, there was an invalidation of 2 of the forgeries on that
How were
very
they
day.
invalidated?
How
were they invalidated?
Well, they were nolle prosecute. They were not, those specifically were sorted out as ones that would not go forward. Now, I will say that there's no,
So the state choosing at the time of the guilty plea to dismiss or not prosecute 2 cases is the equivalent of an invalidation of those convictions?
I would argue that simply because it's not as if the case is different if this was the initial setting, right?
There were no convictions.
There's
in
no
this case,
convictions. I mean, that's what I was going to say.
So-
It's a
Were there
dismissal and a conviction invalidated. If it's dismissed, you're never convicted of it.
So but that's the point. They were there. I think that goes to my point is how they must be invalidated.
But I
is
can
because he walked into the
can
door.
enhance your sentence based on criminal behavior.
I'm sorry.
I can enhance a sentence based on criminal behavior, not just criminal conviction.
Yeah,
So even if the state had dismissed these cases, the trial judge could use that if he found that those things took place but just were dismissed, the trial court can use that to enhance the sentence based on criminal behavior. So they're not convictions, so they, 1, were never invalidated, and 2, is criminal behavior. They're a legal basis for enhancement.
But I guess the problem, what we would have is where we would respectfully disagree is that they were convictions prior to December 13th of 2022. So that would be our position for 1. Because that's why there's an order entered for December 13th of 2022, meaning it would not have been anything to not pursue if it didn't exist to begin with.
So let me make
because
sure
they
that
weren't new
maybe I'm
charges.
misunderstanding. You're saying that at this hearing,
Yes,
when all the amended judgments were entered,
yes,
the state entered new judgments on the 2 forgeries, dismissing those 2 cases?
yes. And I believe that's even broke down in the judge's order on the second page where there's a list of all of them.
Okay.
And that's not been,
Okay, so then let me go back to the beginning, though. You can't have done that if you couldn't get in the door in the first place.
well, and that's a point. Well, we were in the
So
door.
to get in the door in the first place, you have to show that something's invalidated. You can't find something invalidated after you got in the door and made it invalidated, and then said, that's how I got in the door.
Now, I have an answer to that. Once we're there at the hearing, and that is a good question as I anticipate from you, but once we are there at the hearing, and we are now going under these different grounds, the argument you're making is, well, how could you have done it now? Well, not only, if I'm not mistaken, was the motion to reopen, I believe, filed on December 13th of 2022. I could be mistaken. But by allowing it to happen on that day, the state did not oppose it. So the only way I could not have stayed in the door and would have presumably got kicked out of the house is if the state said, wait a minute, you should have said this is earlier, it's too little, too late, you have to go. Well, the statute and the law is very clear. If we make an argument and there's no issues about me bringing it that day or no questions as to the timeliness of it, I am allowed to bring that issue on the same day.
Let me challenge
Yeah.
that just a little bit. I mean, that argument might work in other areas, but it doesn't typically work when we're talking about the court's jurisdiction. And all of these are jurisdictional issues. So coming in under the reopening statute or the statute of limitations, even an agreement by the parties can't confer jurisdiction on the trial court, could not confer jurisdiction on this court. So the mere fact that the state may not have opposed the petition would not have conferred jurisdiction where it didn't otherwise exist. Is that right?
I agree, but when we talk about jurisdiction, it talks about the matter to be heard, meaning if there's no jurisdiction, the court can have a hearing and determine there's no jurisdiction. But what I'm also saying
So
is,
how did the trial court hear? What was the express finding by the trial court that jurisdiction existed? What statute did the trial court rely upon?
now,
to
it
establish
did,
jurisdiction?
I will agree that it relied a lot on what was alleged in the motion, and then it relied on the record as a whole, and it did cite to the TCA, but the order did not specifically say, based on this statute, jurisdiction is available. It did say, I did find tolling appropriate in this matter, so it did make that clear.
Based on what?
Based on the equitable tolling, based on the arguments made by Mr. Anderson. So the court agreed with that argument, and the state did not challenge that position. So we got the statute of limitation issue was not confronted by anyone. It was made aware to the parties.
It doesn't have to be. The law is very clear, and I think that's what Judge Greenholz was just saying. Just because the state stood silently, or even if the state had stood up and said, hey, we think the trial court has jurisdiction, hey, we waived the statute, doesn't matter.
Yeah, but that goes back to my other argument. When the equitable tolling is based on the entire history of what he's been doing on the case, and then you don't bring the entire history up to the case before the court, and it's not sufficient to take judicial notice of the other pleadings because that doesn't incorporate the entire history to show if
But
he's
it's your
trying
burden,
hard.
it's your burden to prove that you, I go back to a question I asked 15 minutes ago. It's your burden to prove and to establish that you diligently pursued it, because it's a jurisdictional question.
I agree.
The state can stand there and go, we agree, he did this diligently, but if there's no proof that you did so, then there's no
Yeah,
jurisdiction.
and the problem I have with that, and I agree, is that after I've proven it, and the state agreed, and then the court reviewed the records and they agreed, it's not fair to Mr. Anderson to say, well, because they're saying it now and we're not providing the entire record, he has to be stuck with the record we are providing to this court when there's other things that happen. Meaning, I agree it's my burden, but my answer to that is we did prove it, and I know we proved it because after we made the arguments, the state did not oppose it and the judge agreed, and she
When
agreed
did you
based on the
prove this?
entire
That's-
record.
Again, I go back to a question I asked at the beginning. When did you prove this?
I would say.
Where was this, what date did the hearing take place
Now-
on in which you proved it?
Now, I don't know the dates. I mean, I don't, and again, but I understand,
Dates then.
I don't have all the
In
dates.
April 22, a pro se Rule 36.1 motion was filed.
Mm-hmm. There were interactions between then, is what I'm saying. It didn't
I'm
just,
not interested in interactions, I'm interested in documents that are in the record or hearings that were heard, that transcripts were created.
that's,
On November 2022, you filed a motion to set aside guilty plea. And then on December 5th, 2022, you filed the motion to reopen the post-conviction relief. And on December 13th, 2022, this order was entered.
correct.
What other hearings were there in this case between, well, let's just start with December 5th and December 13th?
And that, I don't have all those dates. I know that I was before the
Okay,
court multiple
This is
times.
almost a week, or a little over.
I was in court
8
multiple
days.
times.
Well, you were the attorney that filed this motion. And then 8 days later, an order goes down. Were there hearings before the trial judge between those 2 days?
I don't know how we're defining hearings. There were multiple settings before the
Hearings
court.
where you go to court and you got a court reporter, what I want.
Yes.
Where are those transcripts?
I don't know. That's opposing counsel's burden is our point. But they occurred. None of this didn't happen with me just showing up on December. There were multiple court settings.
Well,
That's our position.
You can supplement the record.
We could, but
You didn't.
because when they filed the notice of appeal, the argument they made was the court did this improperly. It was their burden. Now when they come before the court, I don't know what they're going to argue until they're arguing it. And it's not our burden to then say, okay, well, here's all the other hearings and the dates. It's their position to show that there was none, and there were. So that's up to them now
You're
to
telling the
come.
court there were hearings between December the 5th and December the 13th?
There were court appearances in which there was discussion. I don't want to play with the word hearings because there weren't witnesses called, but there were discussions on the case before the judge with the trial court and the state and the defense.
And where did those discussions take place?
Where I believe all in open court. I don't want to. I know there was questions earlier about other discussions. I can't say that all took place in open court. I'm personally aware that there were settings in open court where we're talking about the case, the status of it, where we're trending, what's going on, what the legal issues are, the state asserting, well, these are the issues, and all, those types of things happen.
So, and I know your time's up, but so
Yeah.
the way you just described it, though, it is a general status conference type thing. There's no proof, the way you just described it, there's no proof being presented at any of these.
So-
It's just hey, here's where we are, status conference. So
Well-
that's not going to help us
Well, no,
either.
I don't, to clarify that there's settings where the records were being reviewed because there were several settings where the judge had already reviewed the records and gave a recap, at least on one of the settings. This is what I understand that happened up to this point. So the reason that there's, some of the times we went in, we already all understood what the record was, what was being done. So we're not having an argument on what's in the record because we all knew what was in the record. We'd all reviewed, and we're discussing the record,
Let me ask
discussing
you
the law.
one question,
discussing.
if it's okay. So, to Judge Holloway's point, that you could have supplemented the record, and in response to that, you said, well, I didn't know what the state's argument was going to be. Well, I read the state's brief. The state today did not argue anything different than what was in its brief. And so, for you to say you didn't know, so you didn't know you could what to supplement the record with, I think it's pretty clear. If you're going to argue that there was other proof that the state's not talking about that apparently helps your case, why wouldn't you supplement the record with that?
Well, the answer is, for me, is very straightforward. Once I realize reading their brief what they're going to argue, and then I see that they didn't present the record to the court and that they're the ones who have to present the entire record, there's no need for me to, quite frankly, do their job. To me, it's obvious from the transcript
Except for the fact
that this is not the entire
except for the
hearing.
fact the record before us shows that you didn't put on any proof on how you diligently pursued your claim.
But there's also nothing before you that even asserts, and I don't even think opposing counsel is making the argument that that's the entire record. So there's nothing saying this is in fact the entire record of everything that occurred. So when you give us a partial record, it's equivalent if I had a criminal case and I just presented something on appeal that says he pled not guilty, and then say, well, he was convicted, judge, and here's a transcript where he's pleading not guilty. Or he asserts he's not guilty before trial, and he stood up and said not guilty. And if that's all I provided before the court and said, well, based on the record, I don't know how he could have got convicted. This is all you have to look at. I would get laughed out the room, and you'd say, no, there's more to the story than this. It's obviously more to the story than this. And it would be on me to have provided that story, or again, I'd get laughed out the room and say, well, Mr. Tootin, you know that you needed to provide more than this, because even you're not arguing this is the entire record.
When I talk about the entire record, I'm going to start by saying I'm talking about what happened between December 13th and December the 5th in that 8-day period. Is there any record, any transcript of any hearing between those days?
I don't believe there was any transcripts typed. Now, if you're saying was there any court appearances or any hearings, I don't remember that specific date range. I remember the last setting was December 13th. I remember that prior to December 13th, there were multiple appearances in court and multiple discussions about the case, but I don't remember the date. I don't know what happened. I don't recall.
Those hearings weren't about post-conviction relief and setting aside or filing a post-conviction relief petition or reopening the prior one. If there were hearings, they were about the Rule 36.1 or the motion to set aside the guilty pleas.
It was, I disagree. It was about all of it.
It's 8 days. I mean, I don't know how.
It was about all
There
of
could be
it.
any confusion as to whether or not there was a hearing or whether there's not
No,
a transcript.
What I'm saying is, prior to December 13th, there were several settings in which I came in before the court. In each one of those settings, this matter was brought before the court. At some point, it went from motion to set aside to Rule 36 to motion to reopen. I don't know the exact dates those were,
Again, I told you the
those
dates.
happened.
One was in April, that was the Rule 36.1. In November was the motion to set aside the guilty pleas. On December 5th was the motion to reopen the post-conviction, and on December 13th was the order from the court.
And yes, and those are the filings. Those are not the dates that were appearing before the court, is I guess what I'm trying to say, is that there's separate dates from when you file versus when you appear before the court and discuss the case. So I'm just trying to tell you that there were multiple times we appeared before the court, and there were multiple times where we addressed this case, and by addressing it, I mean discussing it in detail after the court reviewed the entire record, the state reviewed the record, and I reviewed the record. Those are the dates. I can't tell you for certain what happened, but I do know that through the course of this, it went from one pleading to another.
Okay, I mean, all we have before us is the record we have. That's what we base our determination on.
Unless you decided opposing counsel should have provided the entire record. But I
He
agree.
didn't need the entire record for what he's arguing, apparently. He's filed what he thinks he needed. But what I want to know is that, my gut feeling is there weren't any transcripts between the date you filed the motion. There were informal discussions. And there's no proof that we've been shown that occurred before the trial court on which she based this decision.
I understand the position, but again, our position is when I'm in the appellate seat, I'm always the one responsible for producing an entire record. I'd say hold him to that burden.
Well, let's
And
say, you didn't.
I understand
The
your
other
position.
side can supplement, let's say an issue's on voir dire.
Yes.
And the other side wants to file the transcript of the voir dire because they think that's important. They can supplement the record. Either side can.
Mm-hmm.
The state has to file a record that's adequate for them to present their case.
Correct. And we submit they didn't because they said that he did not do anything from 2016 until now.
Even assuming, and correct me on that date, but even assuming that the April date, as if I understood what Judge
Rule
Holloway's talking about,
36.1.
is a 36.1, is still several years after the passage of the act.
Correct.
So there is no proof in this record that your client diligently pursued his rights from January 1 of 2017 until April.
Correct, because it's not the entire record. That's our position. And opposing counsel doesn't allege that it's the entire record. So then how can the conclusion be reached that it's Mr. Anderson's fault that they don't allege they
But
produced the
you
entire record?
you keep saying that the trial court reviewed the entire record.
Yes.
But you can't even tell us what the record is.
I don't have the entire record. So, I mean, I know there was banker's boxes. I mean, I can't tell you what was in each document or each box. I just know that there is more to the record, and it's even obvious from what was presented that there's more to the record. So I can't sit here and tell you what's in every box.
I think that's your problem. As I read the hearing and as I read the trial court's order, I don't see that there is this unfiled record that no one knows about. I just don't see it. So that's, I think, what Judge Holloway is getting at, that's incumbent upon you. The state's filed a record that allows them to make the argument they make and that they think is the full record. If you think something is missing that we need to consider, then it's incumbent on you to supplement the record.
Well, Your Honor, I could tell you as an officer of the court that I know of the issues I told you are the only documents I'm aware of that I can say affirmatively about the Freedom of Information Act and request of that thing. And then when I went to get the record, they did not have all the record, including not even having all of the indictments on this case any longer. So I don't know.
The indictments, on this case are already part of the record.
No, not all of them. I guess there's.
In the fact that we can take judicial notice of our prior cases, the indictments are part of the record if we take judicial notice of them.
I guess my point is, when I did attempt, I did not only could I not get the entire record, I couldn't even get all of the indictments listed on the case to say that I don't know what all is where or who has what, but what I represented is the only documents I feel comfortable representing, because those are the ones I know of that I can say affirmatively.
We don't even get to those documents if we can't decide what proof, if any, there was on your December 5th motion.
I guess my point is the fact that we know that there are more documents and you don't have them, I don't know.
The only ones that I'm, right now, let's assume, only documents I'm interested in
Yes.
are what happened in those 8 days.
Yes.
And
Which it
you were the
sounds like.
attorney that filed the
Yes.
motion that was involved in the case. I would expect the attorney to know what happened in an 8-day period from the time to file the motion until the time the judge grants the motion.
I don't know what happened. I don't recall if there was a court date even between the 8 days or not. I can say for certain there were court days prior. I don't want to represent that. I don't remember if there was a court day in between there. I don't believe that the same day I filed something, it was not typically a day we had it in court, not typically. So I don't know if it was simply a filing or I don't remember. I mean, if I did, I'd be happy to tell you. It sounds like that's the answer you would like to have for me. I wish I had a better answer, but I could tell you there were multiple settings, but I don't recall if I even filed something and had a hearing that day or just filed it and had a hearing a separate day.
All right.
All right, thanks.
Thank you.
I'll be very brief. I just want to say, there's repeated assertion that we've got to file the entire record. We don't have to file the entire record. What's required on appeal is a record that's adequate to address the issues raised on appeal. We frame those issues based upon the legal basis that the trial court has cited for granting post-conviction relief. That's an adequate record for the arguments and issues that we've raised. We do not need the entire record to decide this issue. Sure.
Let me just ask you.
Sure.
I don't disagree with the assertion you just made, but best I understand what the defendant is trying to say is that sometime in this window that Judge Holloway keeps talking about, proof, not our old records, not the post-conviction, not the direct appeal, some sort of proof was filed that establishes the diligently pursuing his rights. Do you have any idea what that could possibly be?
I don't, and had the trial court recited what that proof was or relied on that proof to grant the relief than it did, then I think we'd be in a different position and I'd be more concerned about supplementing the record to make sure that proof is in there. But because the post-conviction court didn't rely on that proof, didn't cite that proof, didn't use that proof in its rationale for granting post-conviction relief, we say that it's unnecessary to be in the, it's not necessary to be in
And
the
so
record.
your position, as I've understood it, is that when the trial court makes the statement that she has relied on all the records, your position is she's relied on the direct appeal, the post-conviction, the same records we can walk into that clerk's office and check out.
Right. I would say that a trial court's assertion that they've reviewed the entire record before making a decision doesn't tie that entire record or certain portions of that entire record into the issues on appeal unless the trial court's order refers to that.
I guess I'm just saying, most liberal reading of that statement,
Yeah.
your belief is she's not talking about something that we don't have access to right now. She's talking about either clearly that one pleading or that one pleading and all the records that are in our clerk's office.
That's my understanding. Yeah. I mean, it's not very specific. It just says transcripts, judgments, appellate orders.
General, can I ask you one other
Sure.
question we didn't address
Sure.
when you were up here originally? Let's assume that the statute of limitations is satisfied. Let's also assume that the record is sufficient to allow us to find that the post-conviction petition can be reopened. The state's third line position is there's no constitutional violation.
Exactly.
Is there a constitutional violation here with disproportionate sentences under the Eighth Amendment? There's a very narrow window for non-capital disproportionate sentences. is a claim at least stated to get into court under the Eighth Amendment?
What I would say is that that claim was not stated in the motion to reopen, and that was not a stated basis of the trial court's order granting post-conviction relief. So admittedly, I've not thought a lot about that issue, but simply because it's not in the pleadings or order below.
Okay, so the petition did not assert as a basis for reopening the constitutional violation of disproportionate sentences under the Eighth Amendment?
Not at all, Your Honor.
Or under, I guess, under the Tennessee Constitution?
Not at all, Your Honor.
All right, thank you very much.
Thank you.
Mr. Tootin, we're going to order you to supplement the record if there are transcripts. And we're going to, certainly anything between December 5th when you filed your motion and December 13th when the judge entered the order.
Am I limited to transcripts, or am I able to talk about, try to track down those documents I said about where we reached out for the Freedom of Information Act, or are we only focusing on specifically hearings? I just want, I don't want to abuse
I'm not
this
interested in the prior
decision.
judgments. We haven't gotten there yet.
Okay.
I'm interested in the proof that was put on where the, that the trial court based her order on.
Okay.
And also, if, I mean, do y'all want to go back to the earlier ones, the motion to set aside the guilty plea, if there are any hearings on that?
Your Honor.
I wonder if we could do this. Mr. Tootin, if you believe there are parts of the record that are missing
Okay.
that would tend to support the arguments that you've been advancing here
Yes.
today, whether they consist of transcripts, documents, or otherwise, perhaps that's what we could consider asking
Yeah,
for something.
but I don't think we need the two banker boxes of the prior
Oh.
cases. We have those
Yes.
in our records. So what documents that are related to these motions? It looks like it started in April with a 36.1.
You know, I want as big a window as possible, so we can, where do I start? I'm limited to April.
Well, I don't know what happened before April. That's when the pro se 36.1 motions filed. That's the
understand.
first thing I
I mean,
see.
so you made it sound like, and I think this is what we're trying to resolve.
Yeah.
That there was an original motion filed by your client that kind of morphed into what we have here.
Absolutely.
And I think what Judge Holloway is saying is April seems to be, to us, to be the start of that
Yes.
process. A 36.1 pro se filed by your client
Right, forward.
forward.
You know, and again, I'm particularly interested, all that, but I'm particularly interested in looking at what happened between December 5th and
Yes.
December 13th. I mean, that's the motion that the court granted the order on.
And I'm assuming no other arguments, so if I get the records at that point, do we address any other arguments, or at that point,
Why
are we
don't you
argued out? I got so many extra
review it?
minutes.
We'll look at it, and if we think other arguments are needed, we'll give both sides an opportunity to argue it.
I submit arguments are always needed, but.
Well, it depends on what you got. If you don't find anything, we don't need any arguments.
Well, the less I got, the more time is needed for argument, so that's.
But I mean, and I want to, I do want to make
appreciate that.
clear what Judge Holloway said. We're not interested in any of our old case files.
I understand that.
We've got those. We want anything new that was filed from April
Okay.
to December, especially anything that took place in that window of the December dates.
I appreciate that. Is there going to be a written ruling on the deadline, or you want to give me a deadline
What-
today?
How long would you like to have to get that? You could
I'm
do-
going to have to, so I'll tell you the process. I'll have to reach out to the clerk's office. I'll then pull up this case, and then I'll have to sit with them to listen to the audio recordings of all the different settings, to sort through the ones that are more relevant from not relevant. And then I'll have to go to the clerk's office as it relates to different filings and find out, do they have the complete record? If not, where is the other filing? Specifically, I'm referring to the time periods in between last court appearance until now, and then have them either give me an affidavit if stuff is missing forever, or tell me how long it would take, and then report back. So that's the steps I have to do. If you give me a deadline and I can't complete those steps in that time, I can always do as we typically do, say where I'm at and go from there. But I just wanted to give you an idea of what the steps are that I believe I'd have to take, so then you can tell me how much time I got accordingly.
Well, transcripts. What we need are, I assume, court reporters type stuff up.
So right now, they don't exist typed, but they do keep all the audio. So I'd have to go through and pick a day with a court reporter where they're
The
out
good
of the
thing is you
courtroom.
only have, I mean, if you really want to focus on what Judge Holloway and the rest of the panel is concerned about, you only have 7 days.
Yeah,
And some, I'm assuming part of that's a weekend, so you didn't have a hearing on those days.
I think the part of the position is, and to go to his concern, as this pleading started to morph. It happened before the actual document was filed. It kind of came that way due to the other discussions.
Well, it
That's the problem.
I wonder if it sounds like we're dealing with some unknown variables, and
Yeah.
to compile what you believe is needed for us to give full consideration to those issues. We don't know how many hearings there are, we don't know
That's-
what the length of the
that's-
hearings are. What if you were to file a status report within 7 days?
That's fair, status report.
And then we'll put down an order granting time, and then you can move to extend that if it's needed. Would that work with the panel?
Thank you.
Yeah. Other thing I would add to that is, while you're waiting for our order, doesn't mean you're starting to get the stuff
No,
put
I'm
together.
assuming that based on what we said here, is regardless if I see an order or not, I need to be submitting a status report by September 14th.
Very good.
All right,
Mr.
thank
Good, Thank you.
All right. Call the next case.
State of Tennessee versus Willie Brown.
Judge Ward,